Court is now in session. Please be seated.
Good morning.
Good morning, Chief Justice. Good morning, Justices. In my reply today, I will first answer the question that Justice McPherson asked me at the end of my submissions on Tuesday, and I will briefly comment on the emergency branch of POG. I will then reply on the POG national concern related issues to address the various displacement arguments made by my friends yesterday, including questions about exclusivity, double aspect, and paramountcy in the context of POG. I will also have a few brief comments on the question of limits in reply to something that came up yesterday. If there is time, I will provide one point in reply on the characterization point. I will be asking this court to turn to Canada's compendium at some points during my submissions today, so I ask that you please have it accessible. First, Justice McPherson, on Tuesday you asked what the situation was on the ground in the anti-inflation reference. That case, I won't ask you to turn it up, but it is in Volume 3, Tab 44 of the Joint Book of Authorities. In that reference, Justice Betts, at page 472 of that decision, referred to committee proceedings as showing that the Act was not enacted by Parliament based on the national concern doctrine. He noted, Parliament did not purport to enact it under the extraordinary power which it possesses in times of national crisis. It is true that Canada in that case did argue the emergency branch as an alternative when they were in the court. That is mentioned at page 417 of the Chief Justice's reasons. At page 422, Chief Justice Laskin for the minority noted that he did not consider it telling against Canada that the word emergency was not used when the legislation was enacted. With respect to David Suzuki Foundation submissions, Canada agrees that this court could find the Act valid under the emergency branch. A reference is not like ordinary litigation, where the dispute is framed by the parties. The reference question here is broad. It asks for the court's opinion on whether the Act is constitutional without specifying or limiting this court's consideration of that question to any particular power of federal parliament. The role of an intervener is to bring forward different perspectives, which can include different views on validity, particularly in references. This morning, my friend from Ontario handed me two cases, Morgenthaler and McSukri, on the role of the intervener. Neither of those cases were references, and in both cases they involved an intervener trying to raise a new argument on appeal at the Supreme Court of Canada, arguments that were not argued below. This is the first instance. The court granted the David Suzuki Foundation intervener status to make the emergency doctrine argument, and Canada prepared its main factum and its reply factum knowing that David Suzuki Foundation would be advancing those arguments. The national concern doctrine is Canada's primary argument, but we maintain our further alternative position at paragraph 54 of our reply factum that if this court does not uphold the legislation under the national concern doctrine of POG, then to answer the reference question, it needs to consider the alternative bases of validity put forward to this court by the interveners. Turning to Turning to POG now and the question of the validity under the national concern doctrine. Saskatchewan, the United Conservative Association, and le Centre Québécois du droit de l'environnement et équiterre each argued that recognizing the cumulative dimensions of greenhouse gas emissions, or the control of interprovincial and international pollution caused by greenhouse gas emissions, as a matter of national concern will displace provincial powers to address greenhouse gas emissions. It will not. The matter is not just greenhouse gas emissions, simpliciter. It is modified and defined by the interprovincial and international aspects. How this court, how that matter is defined, the scope of the definition of that matter is part of the way in which this court and which the matter limits the intrusion into provincial powers. The submissions from the interveners yesterday that provincial powers will be displaced is based on the erroneous premise that exclusivity, the double aspect doctrine, and paramountcy apply differently in POG than for any other constitutionally exclusive power. They do not.
And how would you address the Shadowgate case?
Pardon me?
What would you say specifically about the Rogers versus Shadowgate case?
The Rogers, with respect to Equiterre's reliance on the Rogers communication and Chateauguay decision, the double aspect doctrine did not apply in that case because the pith and substance of the municipal notice of reserve was the choice of the location of the radio tower. It was in pith and substance directed to the federal power. The facts in Rogers communication was that Rogers was constructing a radio tower to fill gaps in their network, in their wireless communication network. In radio communication, the core of the power, the definition of the matter, includes the location of radio towers. Because their specific location, and this is because the specific location of radio towers is key to how networks operate. Canada authorized the location of the tower on a specific property. Chateauguay then attempted to block the location through what was called a notice of reserve. On the facts and the background of that case, the notice of reserve was found to be in pith and substance directed to the location of the tower and specifically directed to prevent the federal power and the location. So it was a direct conflict with the federal exercise of its power.
Can I just ask you before you leave that issue, I'm not asking for a long answer, but when you say that the aspect doctrine doesn't apply any differently in national concern cases than in the other case, is there any specific authority you have for that?
Well, there was the Ontario Hydro case that I took this court to during my main submissions, and I will remind this court that that case is at tab 35 of Canada's compendium. That is directly on point. And I will give a bit more of an answer because the idea that the concept of exclusivity has some superordinate meaning for matters of national concern arises from Justice Ledain's summary in Cowan-Zellerbach, which the United Conservative Association referred to yesterday, describing Justice Betts's description of exclusivity in the anti-inflation reference. Justice Betts was just describing what he saw as the consequences of recognizing the control of inflation as an exclusive power in the context of an act, as we saw, that reached deeply into provincial jurisdiction and based on a more watertight compartment's view of constitutional powers. But when you look at Justice Betts's decision, he was not ascribing a unique meaning to exclusivity for matters of national concern recognized under POG. He was just defining what he saw would be the consequence of recognizing that matter in the context of that act as an exclusive power.
Isn't the trouble that in the quotation itself it says intra-provincial? It's not that it uses the term exclusive, it's that it uses the term intra-provincial.
So there is a difference between legislating in relation to provincial matters and legislating in relation to a federal matter that then affects intra-provincial aspects. There's no doubt that federal legislation regularly affects intra-provincial aspects of a marine pollution, for example. Go back to marine pollution. It was, as Justice Laforêt pointed out, a industry within the province of British Columbia, dumping wood salvage on provincial grounds in the river. So it was provincial property, provincial entity. It was still recognized as a matter of national concern. Federal legislation, under all exclusive federal powers, regularly affect intra-provincial aspects of matters. That doesn't mean that it is in any way different from all of the exclusive powers in the Constitution. And you see this for POG. The displacement argument based on the assertion that exclusivity has a different meaning for POG is not only inconsistent with the Ontario Hydro case, it is also inconsistent with the evolution of the POG doctrine, which the origins of the national concern doctrine arose largely out of prohibition cases in an area in which both federal and provincial jurisdiction was recognized. This was explored by former Chief Justice Fish in his article, The Effects of Alcohol on the Canadian Constitution, Seriously. That article is in our compendium at tab 36. I won't ask you to turn it up, but Justice Fish traces the origins and evolution of prohibition through the Privy Council, from Russell through to the Canada Temperance Federation case in the Privy Council. These cases developed the modern formulation of the national concern doctrine and recognized both federal and provincial jurisdiction over prohibition. So the double aspect doctrine, exclusivity is the same concept in relation to POG as it is in relation to any other exclusive constitutional powers. And recognizing the cumulative dimensions of greenhouse gas emissions does not mean that Canada has plenary and exclusive jurisdiction over all intra-provincial aspects. Rather, the double aspect doctrine provides provinces with significant constitutional space to address greenhouse gas emissions in legislation enacted in relation to provincial heads of power. The double aspect doctrine is an important consideration on the reconcilable scale of impact. It ensures that provincial powers are not displaced. In Saskatchewan's submissions that it is an exceptional doctrine, this is not what the jurisprudence says. And in this, I will ask the court to turn to Canada's compendium and the Supreme Court's decision in assisted human reproduction, which is instructive and is at tab 38 of Canada's compendium. I ask that you turn it up. It's the extract, the first page of the extract beginning at paragraph 184.
Sorry, tab.
Tab 38.
No.
Yeah.
In Canada's compendium.
Oh, sorry. Wrong compendium, sorry.
In the assisted reproduction reference, at paragraph 184, in performing their function as interpreters of the law in the context of Canada's federal system, the Canadian courts have developed a number of doctrines based on constitutional principles, two of which could apply in the instant case, the double aspect doctrine and the ancillary powers doctrine. Because it can be difficult to legislate effectively within a rigid formal framework, these two doctrines introduce a measure of flexibility that enable governments at different levels to cooperate in pursuing legislative mandates. The constitutional analysis required by these two doctrines involves identifying the pith and substance of the impugned statute or provisions. The identification of the pith and substance focuses on the rule applicable to the facts or conduct. The pith and substance is identified by considering both the rule's purpose and its effect. And then the portion at 185 that is highlighted. Activities, acts, or conduct can sometimes be viewed from different normative perspectives, one relating to a federal power and the other to a provincial power. where this is the case, the double aspect doctrine is engaged. And there's a very, very, very long list of cases that carries on to the next page of where the double aspect doctrine was applied. It is a ingrained part of Canadian constitutional law, in no way exceptional. The double aspect doctrine applies for POG cases as with all other heads of power. The multiple access case referred to by my friend from Ecofiscal yesterday is an example. I won't ask you to turn it up, but that case is at tab 39 of Canada's compendium, and the relevant portions are all sidebarred. In that case considered nearly identical insider provision tradings in Ontario's Business Corporations Act and what was then known as Canada's Corporations Act. It was the Canada's Corporation Act that was challenged. Parliament's power to legislate with reference to the incorporation of companies with other than provincial powers was established in the John Deere plow case in a 1950 Privy Council decision under the POG power. Both provisions were upheld under the double aspect doctrine.
I know you've got limited time, but I'm just not understanding what the purpose of this is. If I accept everything you're saying, it just follows that the provinces can take additional measures on the environment without undermining the federal ones. But the moment they undermine the federal ones, then we get a paramountcy problem.
Right.
So they can, on your submission, take additional measures. But that's not really what the question here is. The question that's been put to you throughout the week is, what is the impact of the federal power? How likely is it to displace? How is it likely to have paramountcy over inconsistent measures? That's the concern, where the provinces are legislating under their own heads of power.
Well, there have been two concerns. There has been the federal overreach concern, and there's been this displacement concern. It was the displacement, the federal overreach concern is what my friends from Ontario really focused on. The displacement argument is what the interveners focused on yesterday. And the double aspect doctrine is a very large response to the displacement. Justice Huscroft, you are correct about paramountcy. That is the next place the next point I was going to address. Paramountcy is narrowly constrained. It only applies in the case of a direct conflict.
That's not so.
Yeah, okay, so it is so. In fact, if we look at the Orphan Wells decision, I think we'll pull it up then. The Orphan Wells decision is at paragraph 40.
I'm sorry,
Of
tab what decision?
Sorry, tab 40. The Orphan Wells decision is at tab 40 of Canada's compendium. This was a decision released this year. This is what the Supreme Court of Canada said about paramountcy this year. It was an appeal arising in the context of federal bankruptcy and insolvency, the application of the Federal and Bankruptcy Insolvency Act, and the intersection of that act with provincial environmental legislation. And the court describes the paramountcy, and paragraph 65 is, over time, it notes the provincial legislation is only inoperative to the extent of the conflict. That's at the end of paragraph 64. And then paragraph 65, over time, two distinct forms of conflict have been recognized. The first is operational conflict, which arises where compliance with both a federal law and a valid provincial law is impossible. One enactment says yes, and the other enactment says no. The second is frustration of purpose, which occurs where the operation of a valid provincial law is incompatible with the federal legislative purpose. The effect of a provincial law may frustrate the purpose of a federal law, even though it does not entail a direct violation of the provisions. And then in the next paragraph, it explains how the burden of proof rests on the party alleging the conflict to argue that there's paramountcy. It's not an easy burden to satisfy. It's applied with restraint. The courts must define it narrowly so that each level of government may act as freely as possible within respective spheres of constitutional authority. Paramount.
I said to you that direct conflict is not required, and you answered that I'm wrong about that. Contradiction, in all of the Paramountcy cases, you can have conflict not rising to the level of contradiction. You can have an undermining of the federal purpose that counts. Can you not?
Where the federal purpose is directly undermined. So the provincial government, if there is a legislation enacted that is or a matter of national concern recognizing that the greenhouse gas, the national and international aspects of greenhouse gas emissions, and there's the act is upheld. The provincial government could not enact legislation saying industries are precluded from paying a carbon charge to the federal government. That would be a direct conflict. I can't imagine this because all of the provincial governments recognize that climate change and addressing greenhouse gas emission reductions is important. And I would note that no party here or intervener here before the court has identified any conflicts or potential conflicts between this act or the federal power to control the interprovincial or international pollution caused by greenhouse gas emissions, and any of the provincial legislations or provincial enactments that are in place or planned. No conflict has been identified for this court. The provincial powers to do all of those things in all of those documents that my friend from Ontario included showing what provinces are doing, all of those powers will continue. Provinces can continue to do all of those things.
We've been trying to get a handle on the impact on future provincial lawmaking authority if this federal heading of power is recognized under the POG clause. That's what we're talking about. So it's not whether there are existing laws that are in conflict with or may undermine the federal purpose. I'm asking you, what's the future? And double aspect isn't an answer to that if those laws turn out to be in conflict or seen as undermining the federal purpose. Isn't that right?
So double aspect is an answer to the displacement arguments made yesterday.
It is just a displacement argument.
Yes. With respect to limits, we say that the definition of the matter of national concern includes only the interprovincial and international aspects of the problem defined by provincial inability. So the definition of the matter, the scope of the matter, that's important. Parliament tries
so the matter, the definition of the matter itself, only the interprovincial and international aspects, and you said limited by provincial inability.
Limited by provincial inability.
So provincial inability defines or gives the distinctness or the limit to the matter.
Yes, it defines the matter, and how you define the matter helps give it limits. In aeronautics, the matter is defined incredibly broadly. It was brought into Canadian jurisprudence, initially recognized as the treaty power, and when the word aeronautics captures, the case had 4 different things listed that came out of the treaty, a whole array of powers, all from the treaty, directly adopted into, that's the meaning of aeronautics. And then it was subsequently, once the treaty changed and it was no longer an empire treaty, that power was subsequently recognized by the court as under POG. But the definition of the scope of aeronautics, the definition of the matter, is incredibly broad, which is what leads to conflict on when a province prevents the location of an aerodrome. But with respect to the limits here, definition of the matter is important, and then Parliament tries to stay within its jurisdiction. Like, Parliament doesn't go out of its way to try to overreach into provincial jurisdictions. Where it is alleged that there is overreach in any future enactment, this court will turn to doctrines such as the pith and substance doctrine, the proportionality, to resolve the question, as it has always done. If Parliament enacts a law targeting specific sectors, or having a minimal impact on the national target, or not relating to measures that systemically need to operate nationally to avoid negative interprovincial consequences, then it would struggle to convince a court that the legislation is in pith and substance in relation to controlling the interprovincial and international aspects of greenhouse gas
Give
emissions.
me those three again. I didn't get all three of them. If Parliament does what?
Targets specific sectors,
Yep.
having a minimal impact on the national target, the de minimis argument, or a measure that is not, it's not a measure that systemically needs to operate throughout Canada, nationally, to avoid negative interprovincial consequences. That's the systemic risk importation from, that's really the provincial inability test, and the way it's been applied in the trade and commerce
So
power.
this latter point, the systemic need to operate through Canada, is that effectively encapsulating your leakage argument?
Yes, yes, so for the Act, it meets all of these measures, all of these criteria. We know from the evidence that carbon pricing throughout Canada, and the Act ensures that there's carbon pricing throughout Canada, either by provincial.
Just following that through, in order to be okay, does the Act need to be, does the Act need to be an effective mechanism for preventing leakage?
Well, it needs to have a system in place that needs to be applied nationally because there's evidence that there will be negative interprovincial impacts if it's not a measure applied throughout Canada. So
So I'm trying to, just thinking about that leakage point, you know, what you explained is if there's a regime in one province and not a regime in the other, industry will flee British Columbia to Alberta, and therefore it's not fair and we have to have this across the country. But two things I'm not quite sure I understand. I get the leakage argument for part two, but part one is something that flows through to an individual consumer, in essence. And I don't know that leakage, I mean, I don't know the entire population of Alberta is going to be, BC would be moving to Alberta because of a difference between a 9% and a...
okay, but
So is the leakage argument really a part two argument?
it is also a part one argument, and I'll explain that. Part one applies to fuel distributors and fuel producers. If a fuel distributor or fuel producer in one province is not paying a price on their emissions, if they don't have to pay for the cost, the atmospheric cost of their emissions,
but they are both entitled to and expected to pass that cost on, so it doesn't affect the distributor.
But what would happen is if in Saskatchewan there is no price and in Alberta there is,
Right.
a fuel producer, gas stations who want a fuel distributor, get their fuel from a fuel distributor in Alberta would then purchase their fuel from a Saskatchewan fuel producer because the Saskatchewan fuel producer doesn't have to pay for the cost of its emissions, whereas they do in Alberta.
But in just in an economic analysis where it's a cost that gets flowing through, how would that affect behavior when it's a flow through?
In a flow
I
through,
can see, you know, in your analogy, there'd be no motivation really to have to.
well, in the provinces without the price, there would be no flow through, and the behavior changing signal of carbon pricing wouldn't operate in that province. But in addition, for a fuel producer or a fuel distributor in that province would have a competitive advantage over a fuel producer or distributor in the next province over. So it would be a race to the bottom.
The person in the mid-link could have a bonanza because they could purchase their fuel in Saskatchewan and increase the price and get a windfall.
Yes.
All right, I think I understand that. The second point is where it's a minimum price that's imposed. How does that stop leakage? You mean if you have British Columbia at 9% and you have Alberta at the minimum, say, of 4%, you still have disparities. So if you're only setting a minimum and not setting the actual price, how does that prevent leakage?
So two responses to that question. First of all, there seems to be confusion because it's not a percentage. The carbon charge is based on a price per ton of emissions. It's $20 per ton, the minimum $20 per ton of emissions this year, escalating by $10 per ton each year to 2022, where it will be $50 per ton. That translates into, right now, 4.4 cents a liter for gasoline. If British Columbia, in the exercise of its own jurisdiction, decides that it wants to impose a higher price, then British Columbia is making the decision that they will assume that risk of carbon leakage onto themselves by exceeding the minimum national standard, because that is a choice that they as a province are making. But the act, by ensuring a minimum national standard, reduces the disparity between British Columbia and provinces that are taking extra action over and above that minimum national price. And it also ensures that there is that price signal applied throughout Canada.
Ms. Telslang, we have interrupted your flow a little bit, but it's been helpful. You mentioned one last subject, I think, characterization. Would you?
So on the characterization, my reply on that is very brief. The Canadian Taxpayer Federation took this court to paragraph 16 of 620 Connaught. I commend that paragraph and paragraph 17 of 620 Connaught to this court. That case is in our Joint Book of Authorities, Volume 1, Tab 1. What the Supreme Court said in those paragraphs is that you characterize the charge based on its dominant purpose, and that the dominant purpose of a tax is to raise revenues. The dominant purpose of a regulatory charge, as we saw in my submissions yesterday, can be to change behavior. The evidence in this case overwhelmingly demonstrates that Parliament's purpose in enacting this charge was to change behavior, not to raise revenue. Indeed, the Act itself requires that the revenues be returned to the jurisdiction from which they were collected on an annual basis.
Could I ask you a different question about characterization? Your characterization of this statute is in a single sentence at paragraph 53, and it's this: the cumulative dimensions of GHG emissions is a matter of national concern, period. That's your characterization. There's been a lot of talk about different characterizations, and I even heard you at one point sort of be somewhat complimentary about someone else's characterization. I think you said you could live with it. But unless you say otherwise, I take it that you are standing by that as Canada's characterization for purposes of this case. The cumulative dimensions of GHG emissions is your subject matter.
Well, that is the phrase we chose to identify the subject matter. What matters is the definition of that subject matter. So Ecofiscal has offered as the phrase the control of interprovincial and international pollution caused by greenhouse gas emissions. We say that that phrase captures exactly the same definition of the matter. So if this court is more attracted to the interprovincial and international impacts of control of international and it's not my phrase, so the control of international and interprovincial pollution caused by greenhouse gas emissions, if that phrase is something that this court prefers, what's important is how you define what that matter includes, and that phrase is up to, I mean, the court can pick its own phrase.
So just to, in terms of the words, whatever they are, what you say those words have to capture is that it's only the interprovincial and international aspects, and it's limited by provincial inability.
Yes.
Might need a longer sentence.
It might be, it won't be a noun.
Well, and the ecofiscal factors may well plug into the second branch of Crown-Zellerbach.
Sorry, pardon me?
The ecofiscal words you just read out may be important words in the classification analysis under Crown-Zellerbach, as opposed to using them in the first step of characterization.
What the words that are used to define the matter, that phrase, isn't as important. I mean, it's important, but what is important is how the scope of that matter is defined. What is the single, distinct, and indivisible matter? And I say that because if you look at the aeronautics cases, the first case where it was brought in, it was recognized as Parliament's power under the treaty jurisdiction, you will see that that word, that single word, aeronautics, includes a vast, expansive definition. What matters is what the court says is the scope of the matter as the first step, and that impacts then the reconcilable scale of impact. And we have said that the matter, and this is all along, and this is supported by the evidence, the matter relates to the interprovincial and international effects of greenhouse, and get there hasn't worked. And when there's a provincial, and when BC's used again different.
Or écriture, the same thing where everybody's looking at the pricing in a fairly limited matter definition.
It is limited in its, definitely the matter is limited to a federal control at the federal level related to total emissions. I see I'm long past my time, so I will just conclude as I began. We know that climate change is an urgent threat to humanity. Actions by all levels of government, by industries, and by individuals in Canada are all needed to reduce greenhouse gas emissions. The Greenhouse Gas Pollution Pricing Act is one of the ways Parliament is addressing the greatest challenge of our time. It is a constitutional exercise of Parliament's peace, order, and good government power to address a matter of national concern.
Thank you. Mr. Hunter.
Thank you. For my submission, the court should have before them our compendium, the Joint Book of Authorities, Volume 3, and our primary factor, as well as the two cases I handed up this morning.
Sorry, could you give me that again?
So that should be our compendium,
Right.
the Buff compendium, the Ontario's primary factum that has the Act in it, and Volume 3 of the Joint Book of Authorities. Just need to take to one case in response to my friend's submissions. And there were also two loose cases I handed up this morning.
Morgentaler and Mikisew Creek?
That's correct.
I don't have those.
Oh, you should have them somewhere.
All right.
So in my reply submissions today, I'm going to start by replying to some of the new issues that were raised by the interveners, and then I'll conclude by replying to the two issues between the parties, national concern and Section 53. So on the issue of the issues raised by the interveners, Justice McPherson, you noted there was some case law on this, and that's why I've handed up some case law on this. My friends suggested that the case law about the scope of interveners does not apply to references. If you turn to tab 47, that's the last tab in volume 3 of the Book of Authorities, in particular page 487, this was the reference in relation to the GST, or the Excise Tax Act. So that was a reference brought at first instance in the Alberta Court of Appeal and then appealed to the Supreme Court. And Ontario, in that case, tried to bring a new issue both in the Alberta Court of Appeal and then again at the Supreme Court, and both courts refused to deal with the issue. And they put out, in particular, at the last full paragraph on 487, intervener status is not granted to allow an intervener to raise an entirely new set of issues which are not addressed by the principal parties.
In the paragraph above the quote, it says the issue raised by AG Ontario fall outside the intended scope of the reference.
Yes, and I would submit the intended scope of the reference is not just the bare question, but it is the arguments as framed by the two parties.
The scope of the reference is this act ultra vires, isn't it?
So I would submit that the issues that are being considered in whether the act is ultra vires are the heads of power put forward by Parliament. And the interveners are welcome to raise new arguments on those issues, but are not welcome to raise completely new heads of power, and certainly not welcome to raise completely new issues outside the federalism analysis. And it's on that point that I put forward the Morgentaler case, which admittedly was not a reference, but did deal with the question of what are the issues in a federalism challenge. And in that case, the main argument being put forward by the challengers to the act, Mr. Morgentaler, was that the Nova Scotia regulations at issue were criminal law, and therefore ultra vires the province. That's at the bottom of page 463. The intervener, Carroll, tried to raise a new head of, in that case, because it was a provincial statute, invalidity, but I submit it's the same when we're talking about validity, saying, no, it's POG, it's national concern. And the court held the intervener cannot introduce a new issue on the ground, this is at the very bottom of 464, on the ground that is a response to an argument made by the appellant if the respondent has chosen not to raise the issue. The last case, and I won't ask you to turn it up, but Mikisew Cree deals with what interveners are allowed to do, which is raise new legal arguments on the issues raised by the parties. So I accept that my friends are able to raise new legal arguments on the scope of the national concern doctrine or on Section 53, but I would submit they should not be allowed to raise new heads of power that Canada has not relied on. And in any event, they certainly, this is turning to the Section 35 arguments and honor the Crown arguments made by some of my friends, they should not be able to raise completely different constitutional arguments, particularly about the constitutionality of Ontario's environment plan, which is certainly not at issue in this reference. The one other point I will make in relation to Section 35 is that there was some suggestion that you should interpret the scope of the national concern doctrine taking into account of Section 35 on the basis that perhaps a province won't do enough. If there's a claim that a province or provincial legislation and policies have not addressed the environment and therefore violate Section 35 rights, that claim should be brought in a proper proceeding where the Section 35 right that is alleged can be proven on a proper factual record, and Ontario can defend it directly on that basis. That's not this reference. Turning then to the criminal law, I'd ask you to turn up the firearms reference, which is at tab 45 of our compendium. And in particular, paragraph 34 of that reference. Now, my friends who addressed criminal law spent a lot of time on the criminal law purpose point, but it's important to recognize what the Supreme Court recognized here.
I'm sorry, I'm not with you. I need the reference.
Sorry, it's tab 45 of the compendium, paragraph 34 on page 805.
Thank you.
So the Supreme Court held the finding of a valid criminal law purpose does not end the inquiry. However, in order to be classified as a valid criminal law, that purpose must be connected to a prohibition backed by a penalty. The 1995 gun control law satisfies these requirements. The Firearms Act and the Criminal Code prohibit the possession of a firearm without a license and a registration certificate. So it's a prohibition with exemptions. And then they are then backed by penalties. Similarly, in RJR, there was a prohibition on advertising tobacco. The fact that there wasn't a prohibition on something else, tobacco, There was still a prohibition on the conduct that the purpose was Parliament was trying to promote. Here, there is no prohibition on emitting greenhouse gas. The purpose Parliament is trying to achieve, reducing greenhouse gas emissions. This is not criminal law. The last point I'd make on that is what this is the type of detailed regulatory scheme that the Privy Council in the Reinsurance Act case, which can be found at tab 22 of the compendium, and the Supreme Court in the assisted human reproduction case, in particular Justice Cromwell's swing vote decision, found cannot be supported. Remember, in assisted human reproduction, the court upheld the straight-out prohibitions. You shall not create chimeras. You shall not create certain other uses. You should not sell gametes for profit. But what it struck down were the detailed regulatory intrusions into the provincial sphere, as they were not supportable by the criminal law purpose. Turning then to emergency.
I'm sorry, turning to?
Emergency power. My first point on this is that on Tuesday, Canada conceded in my submission that Parliament did not act on the basis that greenhouse gases were a national emergency, because Council for Canada stated the information needed to know that didn't come out till after the fact. And of course, you can't retroactively say Parliament intended to act on the basis of an emergency. It's required on that power for an emergency that was determined later. And I would submit that that is a concession of fact, not just a concession of law, and therefore is binding on this court. This is different than the anti-inflation reference. As my friend noted, in that case, Canada did argue in the alternative from the get-go. The Act could be supported as emergency legislation based on Parliament's intention at the time the Act was passed, even though it didn't use the express words emergency. In any event, even were the Act intended to be addressed as an emergency, it does not fulfill the key limitation on the emergency power. And remember, the emergency power is very broad because it basically eliminates the division of powers to the extent of the emergency. And that is why all three judgments in the Anti-Inflation Act specifically said it has to be limited, it has to be temporary. And that is because, and I'll just read, you can turn it up, it's at tab 43 of the compendium. I'll note both the Chief Justice and Justice Ritchie have this indication, but the best discussion of the reasons for it are in Justice Betts' decision at page 461. This is the paragraph at the end of the highlight, the black line section on page 461. There are no limits to the emergency power, he says at the end of the first full paragraph, other than those which are dictated by the nature of the crisis. But one of those limits is the temporary nature of the crisis. And that's because at the end of the next paragraph, the cases make clear that in practice, the emergency doctrine operates as a partial and temporary alteration of the distribution of powers between Parliament and legislatures. That limitation is crucial because without it, the emergency power knows no bounds. It just completely amends the Constitution forever and gives Parliament plenary power over whatever is needed to address the crisis. But the Act is not intended to be temporary. Its preamble makes that clear. The preamble can be found in our factum, tab B2, being a preamble right at the beginning of the Act, and in particular on page 2 of the Act.
Just what tab? Again?
So it's tab B2 of our factum, and it's page 2 of the Act, just after the table of contents. The second full paragraph on page 2, whereas the Government of Canada is committed to achieving Canada's nationally determined contribution and increasing it over time under the Paris Agreement. 4 paragraphs down, whereas the pricing of greenhouse gas emissions on a basis that increases over time is an appropriate and efficient way to create incentives. The scheme of the Act itself, the schedules set out, and I took them to you in my original submissions, the increasing rates up to 2022. The power of the Governor and Council to further increase those rates by regulation, not even having to go back to Parliament to do so. And as my friend said, we don't know what the price will be after 2022. I submit it's unlikely to be lower, it's unlikely to stop. And that is because the very logic of carbon pricing, as my friends put in some of the questions, Justice Huskoff, you posed, it's necessary but not sufficient in my friend's submission. It's not as if even if the Act works as intended and it provides behavioral incentives, those behavioral incentives can't stop because then there would no longer be that signal. No, this Act is about as temporary as the Income War Tax Act was. As we all know, we're still paying income taxes today. We'll still be paying carbon taxes many, many years in the future. It is not temporary legislation that can be supported under the emergency power. Next, I would like to turn to the general trade and commerce power. And many of these submissions will apply as well to the national concern because the powers are similar. Because general trade and commerce also has to be confined so that it doesn't swamp property and civil rights and matters of local concern. Although, again, I will note that unlike national concern, it does have to have a basic minimum content. It is an enumerated power which the federal government must have. It's very different when we're talking about national concern and asking to create a new power that was not in the original distribution of powers. But this Supreme Court, in the first securities reference, which can be found at tab 47 of the compendium, made it clear the limits that had to be placed on the general trade and commerce power. And at paragraph 79, which can be found at page 873 of the decision, the court summarizes General Motors and then talks about what these limits have to look like. In the end, Justice Dixon, that's Justice Dixon in General Motors, opined that to fall under 91(2), legislation must be underlined qualitatively different, the key words, for both, in my submission, trade and commerce and national concern, from anything that could practically or constitutionally be enacted by the individual provinces either separately or in combination. Another set of keywords. He goes on to say that Justice Dixon contrasted laws directed at general regulation of the national economy with laws merely aimed at centralized control over a large number of local economic entities, indicating that only the former fit within the purview of 91(2). Centralized control of a large number of local economic entities. Sounds like the Act. There is nothing wrong in our Constitution with different provinces choosing their own ways to address national problems, in accordance with the will of their electorate. There was a similar concern in this case, the securities reference, that some provinces might adopt more stringent regimes than others. And the Supreme Court did not find that that concern required the creation of a national securities regulator. There was the same concern that everybody else has one, we need one. Well, other countries have different constitutions than ours. Our Constitution is our Constitution, and we must work within its terms, not those of the United States Constitution or the Australian Constitution. And we put those in our materials, the relevant provisions. The principles of federalism and democracy that underlie our Constitution mean there need not be unanimity among the provinces. National standards, even if desirable, are not themselves a reason for federal jurisdiction. And at paragraph 83, the court, which is on page 875, the court summarizes this point. In the middle of the paragraph, to be genuinely national in importance and scope, and that's the overarching test for the general trade and concern power, it is not enough that the matter be replicated in all jurisdictions throughout the country. It must, to use the phrase in General Motors, be something that the provinces, acting either individually or in concert, could not effectively achieve. To put it another way, the situation must be such that if the federal government were not able to legislate, there would be a constitutional gap. Such a gap is constitutional anathema in a federation. In answer to a question that you posed, Chief Justice Strathy, there is no gap. The provinces working together with the federal government acting under its enumerated powers, can regulate every last greenhouse gas emission emitted in this country.
But what the federal government is doing is saying nationally, this is where we have to be at. That's not something really that a province can do, can they?
Well, that is really begging the question, because that was the point I just took the court was making in the securities reference. The exact same argument was made. No one else can create a national securities regulator. How can we have one uniform securities regulator that can make sure there isn't these interprovincial conflicts, that makes sure that there isn't, securities leakage, to coin a term, between provinces? And the Supreme Court said no. National standards, maybe they're desirable, but they're not a reason to change the division of powers, even under an enumerated power. I'd say even more so under national concern. And it's important to remember, we've talked a lot about the impacts of greenhouse gases, but if you turn the telescope around, greenhouse gases are emitted locally by local industries, by local factories, by local transportation. Now, there are exceptions for interprovincial transportation, all the things that Part 3 governs, which we're not challenging. But the vast majority, and if you'd like the details of where those all come from, I believe there's a question about Justice McPherson, about where were the sources. Page 24 of our environmental plan, there's a nice pie chart that shows the sources. And the vast majority are transportation and home heating, also agriculture, which, as I'll come back to, the Federal Act doesn't apply to. But it's basically everything. And the vast, vast majority of those activities, what the Act seeks to govern, what a federal matter would seek to govern and could govern, are local matters. It's the heating your home, driving your kids to the hockey game. Those are the matters this Act governs, and those are provincial. There was also a comment about air pollution being perhaps prototypically federal. I would submit that is not the case. One needs only look at the Environmental Protection Act and the detailed regulations that are set out under it and under the similar legislation in every province and territory. Air pollution is predominantly regulated by the provinces. Again, the federal government has a role to play, particularly under its criminal law power, but it is not a single matter of national concern or a matter of general trade and commerce.
The worst impacts by far in Canada of greenhouse gases are the 3 northern territories. They're facing the risk of temperatures rising from 3.5 to 7 degrees. The biggest emitters are Ontario, Alberta, and probably Quebec. What's the incentive for Alberta, Quebec, and Ontario to do things that are going to be responsive to a horrible problem up north? Just on the news the other day, there was the chief of one of the bands up in the Yukon was saying the caribou this year are 85 kilometers away from where they have been for centuries. 85 kilometers away, and entirely because of the melt up there. I mean, is that going to be the lead item on the Ontario news? Hardly. Is that going to be in the minds of the Ontario government? Hardly. So does it really work to say 13 governments are going to have to do this together? Some of them won't want to do it at all. The national government sees the whole picture and says, we need to respond as a nation to this. And here it is.
They need to respond as a nation in a way that respects our Constitution, which is a federal constitution. The same could have been said about inflation in the 1970s. The same could be said about the millions of people out of work. Most of those were in the prairies. Why would Ontario care about wage and price controls and fair hours of work in the Depression? We're a nation, but we are a federal nation, and we do work together. And I would submit also, of course, that the North is not just the territories. It is the north of Ontario, the north of Alberta, the north of Quebec. Those provinces do care. Their electorate does care. And those are matters that the electorate will address. How they choose to address it is a policy matter that is for the electorate and the legislatures, not for the courts. But they will within their respective heads of jurisdiction. It does not require, as my friend said, throwing the Constitution out to solve this problem.
So do I take it, though, that your submission would go so far as to say that the provinces have the right not to do anything?
Yes. And the federal government could respond with its enumerated powers to the degree that those powers allow. We should not create a brand new head of power.
Just to follow up on something else, I'm maybe getting ahead of you, but on the issue of national concern, I did not hear you dispute the fact that or the legal proposition that a matter local and private may rise to the level of being a national concern. That was the old case that said that, and it seems to be still accepted.
Yes.
And can one not say that greenhouse gases have achieved that, have reached that point, that they have become, yes, they're national, yes, they were originally local, worried about the smokestacks and so on, but they become of national concern?
And so I would submit no, because they do not meet the test for determining when a matter has so become. They are not single, indivisible, and distinct, and recognizing them as a matter of federal concern would imbalance the federation. So really, to go through the test is to answer your question.
All right. So even though in theory they might be of concern to all Canadians and that they've gone beyond perhaps what the provinces can regulate, if they don't fall within the test, that's it.
Well, I'll repeat what I said in Saskatchewan. A matter may be of concern to the nation and may be an important existential matter. Does not mean it is a federal matter of national concern within the meaning of the Constitution. And I submit the provinces and the federal government working together do have the tools and are acting to face this problem. So that's actually a good segue into the national concern doctrine. My first point is that when considering whether a new matter should be added to the federal list of enumerated powers, the court cannot just look at the particular act that is being considered. You have to look at the ramifications of the matter itself. And you can't just define the matter as the act. That begs the question. All the heads of power that have been recognized under the national concern doctrine are an area of human activity. Radio communications, aeronautics, the national capital region, nuclear energy, marine pollution, et cetera, et cetera. Not just one policy response to that sphere of human activity. And once a matter...
The cases do say you have to define it narrowly.
I do agree you have to define it narrowly.
Yeah.
But it can't be so narrow as just this one act is now federal. You're giving Parliament a sphere of a head of jurisdiction over a matter, a sphere of human activity, and then it can then choose how it wants to deal with that matter going forward.
Do you have authority for that proposition, what you've just said?
That all the cases talk about we're recognizing a new matter, and a matter
which is the pith and substance of the statute.
Right, it's not the statute itself. And if you look at the analysis they don't just say, we're recognizing you can control marine pollution by putting this particular limit on it in this particular act. We're not just controlling inflation by this particular act. The anti-inflation reference is actually a very good example because Justice Betts doesn't just say we're just looking at this one act. The whole discussion that I read out is about, but Parliament would then have power to do this and this and this and this because they all deal with the matter, the sphere of human activity that is said to be of national concern. And once it's recognized, it then becomes essentially another enumerated power. The court doesn't revisit whether it exists in subsequent cases. It's on the list, and it then can be used like any of the other enumerated powers. And to give an example, the radio reference and the aeronautics reference, they just considered one act to implement one international treaty at the time, and whether it was inter-virus parliament or not, and they both held yes. Radio, a little different, it was under 132 as well. But the heads of power that were created in those cases, as Canada is asking this court to create a new head of power today, have expanded over time. And they support hundreds of pages of federal legislation, which is paramount whenever they have an operational conflict with, or even when provincial legislation is just found to frustrate their purposes. And in fact, even if there's no federal legislation, the mere existence of the power under the interjurisdictional immunity doctrine renders provincial laws, zoning, labor relations, building codes, inoperative and inapplicable under IJI. So as Lacombe and COPA, my friends, took you to. For example, Ontario has no power to regulate intra-provincial aeronautics, to regulate nuclear electricity generation. And that is why the courts have been so cautious in recognizing new matters of national concern.
Is your position that the power is displaced when it's POG, or that the double aspect doctrine can operate?
No, the double aspect doctrine applies, but the problem is that a provincial legislation that is in pith and substance relating to the new federal matter, that's ultra-virus. And so Lacombe's a good example of that. It wasn't, unlike COPA, which was a Paramountcy and IJI case, Lacombe was, this zoning bylaw was really trying to say we don't want any float planes on our lake. It was in pith and substance the regulation of aeronautics, and therefore it was ultra-virus, not just inapplicable or inoperative. So I agree that there will be provincial legislation that can apply under the double aspect doctrine, but there'll always be a risk of a challenge, and legislation that is found in pith and substance to be about cumulative aspects of climate change or any of the other definitions that have been suggested would be ultra-virus. So it's narrower than I think some of my friends suggested, but there is some risk of displacement. To give just one example, a bit easier perhaps with taxation, because there's lots of provincial and federal taxation on the same matters, but Quebec's cap and trade scheme, it's very similar to the federal scheme, and the federal scheme recognizes it, Quebec is not a listed province, could well be vulnerable to challenge, because it could be said to be in pith and substance about reducing greenhouse gas emissions. And as we know, reducing greenhouse gas emissions one place reduces the cumulative total.
It's not without some significance, though, as your friend pointed out, that in the whole panoply of provincial environmental regulation, which has to be one of the most regulated areas in the country, there's not a single provision that you've pointed to that is in conflict with this legislation.
Well, no, but the point is, I think that Justice Huscroft made, the point is the provinces can't take a different approach. They can't say, we're going to do very incredibly stringent regulations, but they don't have a price. They'd have to do that, and of course they do have a cost, they don't have a price. They would do those measures. Ontario hydro consumers are still paying the cost of closing the gas, but they wouldn't be able to not have the price on top of it.
When you're making the submission that this legislation in this area is going to sterilize provincial ability to deal with the environment.
I'm not making that submission. I'm saying there is a risk that some provincial legislation, if it were found to be in pith and substance, I think the real risks, the stronger risks, are IJI and Paramountcy. But I do have to say that as a analytical point, there is a risk that legislation found in pith and substance to be in relation to the new federal matter. Aeronautics is a great example of that. Radio communications is a great example of that.
So that we should determine that this legislation is invalid because there's a risk that at some point some legislation will be found to be.
No, you should find unconstitutional because there is no limit to the claimed federal power. It's not single and distinct and indivisible, and it would unbalance the federation by taking a broad swath of local matters and federalizing them. I mean, just to give an example and to contradict the submissions of my friends from Ecofiscal, who said, well, it's not a problem. Nuclear energy generation, marine pollution, those are distinct matters. nuclear energy is a really good example. The ratio of Ontario Hydro is that the nuclear pile that has the neutrons and then the turbine, the steam it heats and the turbines, those are federal. The electricity transmission that then goes out from there, just as it would from any other generating station, are provincial. There's actually a literal dividing line between federal and provincial jurisdiction. That's an example of an ascertainable limit. But despite being repeatedly asked to, again and again, by this court, Canada could not give an answer to what the limits of this proposed new power are. To say that it's provincial inability is the test cannot be the answer to the test. They have to actually give a dividing line, and they could not. What they said, well, there's three things, and none of them give a dividing line. One, cumulative atmospheric concentrations. The word cumulative says it all. You're adding them all up. Every little bit affects cumulative atmospheric concentrations. Two, climate change impacts of those emissions. Again, every little bit adds. And three, really just saying the same thing in a different way, Canada's total national emissions. Again, it's the total of every little bit. And my friend took you to Justice Betts' definition in the anti-inflation reference of single, indivisible, and distinct. And not one of those branches are met. Regulating GHG emissions regulates the aggregate of activities that produce them. It is not distinct from provincial matters and covers such a wide range of activities that there are no bounds of form, as Justice Betts put it. Now, my friends from BC tried...
Excuse me. What do you say today? Your friend referred to the interprovincial and international aspects. So regulating greenhouse gas emissions at that level only. I think that's what she was saying, at the international and interprovincial level.
Well, first of all, that's certainly not what the Act does. So if that is the matter, the Act would be ultra-virus it. And I'll come back to that when I talk about BC's submissions in a second. Secondly, again, there's no dividing line. My friend's whole submission is we have to be able to regulate the provinces. We have to be able to tell them what policy measure to choose, because every emission they make contributes to our international...
What I took it to mean is that the law operates at a national level. It is only looking at the big picture, the global picture. It's not going down into the details. So it's setting a national target, and it's similar to the submissions made by some of the other interveners.
It's similar to BC's submissions. It's basically setting a national budget
eco-fiscal
and allocating that. And so actually, let me turn right now to my submissions on BC's submissions. And then I'll come... Actually, before I do, let me just give one more point, just because it's really an aside. A number of parties refer to the Interprovincial Cooperatives case as if that were a POG case. It's not. It's a challenge to Manitoba legislation. So I just want to make that point before I move on. Turning to BC's submissions, I would submit they do not help. Parliament has not attempted to just set a greenhouse gas emission budget for the whole country. It has told the provinces how to reduce greenhouse gases. They have said a carbon price is the only way. If you don't have a carbon price, you're going to have ours. No matter how stringent the actions you've taken, no matter how much success you've had, you're going to have a carbon price.
Isn't that a policy choice? So they're saying we want to attack this on a national level, and our policy choice, which is not a matter of constitutional law, is pricing.
But that would be the same argument that what Canada, and to be fair, Ontario, made in the securities reference, that we need to attack securities regulation on a national level. And the Supreme Court said no. They said you cannot intrude into every detail of provincial regulation and tell the provinces how to fix the problem, because that would unbalance the federation, even more so when we're talking about the national concern doctrine than the trade and commerce doctrine. And the Act, in fact, Parliament has tried to go further. It has, contrary to my friend from British Columbia's submissions, told the provinces how to allocate greenhouse gases between interprovincial industries. The regulations they are proposing to enact under the Part 2 of the Act set out different emission limits for 38 different categories of industrial activity. And in some cases, there's subcategories within those 38, so it's really more than 38. The Act expressly allows the Governor and Council to list not just provinces, but areas of provinces. So we can treat different parts of the provinces differently. And as the chart my friend took you to in her compendium yesterday, or sorry, the day before yesterday, shows, Parliament has and the federal government have deliberately picked favorites. As my friend from BC, well, they can't prefer iron and steel to automobile manufacturing. They have done exactly that, as well as nitrogen production, concrete, and lime production, even though some provinces don't even have some of those industries. And they've exempted agriculture entirely from Part 2 and even from Part 1. Fuel use in many agricultural uses, you can get an exemption certificate and not have to pay the Part 1 fuel tax. Even though, as if you look at the chart, agriculture is one of the major sources of greenhouse gas emissions. So Parliament has tried to interfere in those interprovincial matters, and if granted the power it seeks in this case, would have vast scope to do so even more in the future. They've already said this is just necessary, it's not sufficient. And as Justice Huscroft pointed out, they're probably going to do more if granted this power. With no line, nowhere to say where does the federal power end and the provincial power begin. And I would submit, as Justice Betts warned in the anti-inflation reference, to allow the provincial power to be granted would render the division of powers nugatory. It should not be recognized as a matter of national concern.
So if there were legislation following up on BC's submission, which said, here's our national budget, and we're going to have provincial budgets, and here's the budget, and Ontario, you're required to meet this, without saying how, would that have satisfied Ontario's concerns?
It would certainly be less problematic. Of course, the devil's in the details and what the consequences are for saying how, and what we'd have to look at that act if it were passed. It would be less problematic. It would give more freedom. But the question would still remain, A, with the act itself, what are the ramifications? And B, with the proposed head of power that would have to support such a hypothetical act, is there a line that can be drawn? Is there a dividing line? Because the ultimate concern, the matter that would underlie that would still be, oh, we're concerned about the national impact. And that national impact is by definition an aggregate. I would submit the better way, rather than any such attempt at coercive federalism, is the cooperative federalism that has served our country so well. That we work together, we come to agreements. You know, obviously the players have changed, but the interest. I'm out of time. They never want to turn off. There we go.
My clock will give your clock another 10 minutes.
Perfect.
If you need it.
So I'll just finish up on national concern. I just want to deal briefly with Section 53. But Associate Justice Hoyt, the point is there would still be no limits, and the better way is to work together with the provinces, come to agreements, come to national targets, and let the provinces who know their local people best, the needs of their societies, the needs of their industries, work together to solve this problem, not impose a one-size-fits-all, Ottawa knows best solution by coercive legislation.
Sorry, just one more question. Am I right that the thrust of your argument is focused more on Part 2 than on Part 1?
It's focused on both.
But the evils that you see, the transgression, if I can put it that way, you argue into provincial, dealing with specific industries is more a feature of Part 2 than Part 1, is it not?
I mean, I would agree that Part 2 is more intrusive. Part 1, and the reason it was enacted still to be as my friend from Saskatchewan suggested, a bludgeon, if you will, to say provinces do it our way or else. That is still a problem. The head of power my friends rely on to support it is still a problem because of that lack of limits I've discussed. But I agree that Part 2 is even worse.
All of the government's advertising in the last week has been about Part 1, hasn't it? Including the stickers on the gas pumps.
I can't speak to government advertising. I mean, obviously it's The question is, what's the constitutionality of the federal act, not what the policy ramifications of it, the policy wisdom of it. That's a matter for the politicians to debate amongst themselves. Turning then just to finish off on Section 53. It's important to remember that Section 53 is a separate and distinct test from the division of powers. So even if the legislation is valid under a pith and substance analysis, the charges it imposes must still be analyzed under Section 53. And to sum up that test, if legislation imposes a mandatory financial exaction with the force of law, there's two options. A, it's been expressly authorized by Parliament as a tax, or B, fall into one of the exceptions. It's a user fee, it's a proprietary charge, or the one of relevance here, it's a regulatory charge. Now, dealing with branch A first, my friend conceded that Parliament had no intention to impose taxation, which is what Section 53 requires. And we've taken you to already. In fact, not only did she say so, the parliamentary assistant to the Minister of Finance, who one would hope knows whether a measure is taxation or not, stood up in the House and when the question was put to him, said, no, 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 this is not a tax. You can't ask for clearer evidence than that. Turning to the second branch of the test, is it one of the exceptions? Is it a behavioral modification regulatory charge? Now, there was a lot of discussion about the passage from West Bank and some of the earlier cases that were cited in West Bank. But I suggest the key point is the subsequent case, 620 Connaught, a case involving a federal charge where the Supreme Court expressly left open the question of whether not only did there have to be a nexus between the regulatory purpose and the purpose of the act, modifying behavior, but also between the funds raised by the act and the regulatory purpose. And it simply does not make sense in the order of our Constitution to allow governments to raise funds for general purposes, such as Canada is doing, writing tax refund checks to every individual taxpayer in the listed provinces, to various companies and municipalities in the listed provinces, and to the treasuries of the opt-in provinces through a behavioral modification charge that is exempt from the constitutional limitations on taxation. If governments could do so, they could levy what are usually called sin taxes on any behavior they don't like, and they want to modify, without the need for parliamentary scrutiny.
Well, don't you have to look at the purpose of the legislation? Isn't that obvious? That you look at the purpose of the legislation, you make a determination, is it to raise money or is it to modify behavior?
But I would submit that's not enough, because many taxes have the purpose of modifying behavior. Just to give one example, the federal tax on cigarettes that's gone up and up. It's to raise revenue, but it's also to modify behavior.
So you cannot simply modify behavior as an objective of federal legislation.
You can, but as one of my friends put it, there have to be some strings attached to how you use the funds. If you want no strings attached, then go to Parliament, have the courage of your convictions, stand up and tell Canadians the truth, you're raising taxes. And then if you raise taxes, you can spend them on whatever you want. That's the point of a tax. It's a mandatory exaction for general purposes. A regulatory charge, both the charge and the funds used must have a nexus to the regulatory purpose in our submission. Because otherwise, it's all too easy to get around that parliamentary scrutiny that applies to taxation measures, to get around the limit on intergovernmental taxation in Section 125, and from a provincial point of view, not admittedly for the feds, get around the limitation on provincial indirect taxes. Regulatory charges can be as indirect as you want. So to give an example under the Act, this is not a case where the funds are being used to build, can only be used to build transit projects or to spend on retrofitting your home, buying more energy efficient appliances. No, they can be used for anything. It's just a credit adds to the bottom line, you're going to get a bit more money back in your tax refund. And you could spend it on anything, even things that increase greenhouse gas emissions.
Or you can say, wow, I just got $500. That's the first time I've ever got a check like that. I think I'll drive my car even less next year, and maybe I'll get $700.
You might.
Totally good nexus between.
No, but a nexus isn't you hope people do things. A nexus is you're tied to promoting the purpose. And there is no such link here. Even more so when it's an opt-in province and it just goes into the provincial treasury and spent on whatever they want to put in their next budget. So what Parliament is attempting to do under this Act is taxing and spending. And they can do that if they impose a tax. But they were very careful to draft the Act in a budget bill that had lots of tax amendments, never using the word tax in the Act. They had the parliamentary assistant, the Minister of Finance, stand up in Parliament and say, this is not a tax. They made that choice. They picked their lane, and they should live with the consequences of that, which is that you need to tie the use of the funds raised to a specific purpose, not a general purpose. And by failing to do so, in our submission, the Act infringes Section 53, and even if it is valid under pith and substance, the charges it imposes are ultra-virus Parliament. So to conclude, Ontario's submission is this Act is ultra-virus Parliament under the division of powers. It governs a broad range of activities that are within provincial jurisdiction. It cannot be supported under any of Parliament's enumerated powers, even were it open for this court to consider the submissions that were mostly made by the interveners, not Canada, on those heads of power. And however you phrase it, you've heard many different definitions, and I submit they all have the same fatal flaw. There is no dividing line. There is no ascertainable limit on the scope of the claimed new federal power. And to recognize that as a new head of power would, it'd be appropriate for a unitary state. It is not appropriate for a federation where the provinces and the federal government have to work together within their respective spheres of authority. And that is what they have been doing. That is what they will, and I would submit it's what this court should allow them to continue to do, and to respect the boundaries our Constitution draws. Subject to any questions, those are my submissions.
Thank you. Thank you both for your submissions. We'll reserve judgment in this matter. Thank you.